From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Supreme Court hears arguments on President Biden's student loan forgiveness plan. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Alicia Finley and Kim Strassel. Welcome to you both. When President Biden announced last summer his plan to forgive $10,000 per person in student loans for people earning up to $125,000 a year, one of the big questions was whether any opposed party would have legal standing to challenge it. And yet here we are Tuesday. The Supreme Court has just heard oral arguments in a case that could strike down the debt forgiveness program. And let's start with that standing question. I thought this was an interesting back and forth between Justice Samuel Alito and the lawyer representing the federal government, Solicitor General Elizabeth Prelogar.
I understand a big thrust of your argument to be that Missouri lacks standing because MOHELA is separately incorporated. But why should that formal distinction govern the determination of injury in fact?
So we think that the injury in fact analysis here has both a factual and a legal component. In the first place, of course, we're making arguments that even if there's a financial injury to MOHELA, the state hasn't carried its burden to show that that will have downstream effects on the state or that those would be cognizable. And MOHELA hasn't paid money into the relevant state fund for the past 15 years. It said that further payments were not deemed probable even before this plan was announced. But even putting the factual discrepancies to the side, there's a fundamental problem as a matter of law with the claim of injury. And I think it arises directly from two sets of black letter law principles. The first is that the whole point of incorporation is that you're creating a separate legal person with its own rights and interests. And Missouri has derived substantial benefits from structuring MOHELA that way. And the second is the basic Article 3 principle that a party has to come to court and assert her own rights and interests. Right. She can't invoke the interests of a third party.
Alicia, I hope you can remind us what exactly is MOHELA, how Missouri has set up this system, and what do you make of this standing question?
So MOHELA is a federal student loan servicer that was established by the state legislature many years ago. And there are a number, when we talk about federal student loan servicers, there are a number of them, but basically what they do is service student loans. You know, they don't originate the loans per se, but if at least at this point, all of the students who are borrowing directly from the federal government. You know, they help coordinate and ensure that students, repay their loans. If they have any questions, they answer those questions and such, and then they get a fee from the government for servicing those loans. So MOHELA, or the Missouri argues that because of the student loan forgiveness, MOHELA will generate less fees. And as a result, this will hurt Missouri because under the law that the Missouri legislature passed, MOHELA is required to make certain payments. I don't know exactly how much, but payments back to the state treasury. And it also funds scholarships for in-state students to attend in-state colleges. And so therefore, Missouri actually has a concrete interest and it could suffer a concrete injury because of the student loan forgiveness. And understanding that you actually have to show an injury concrete, in fact, particularized, can't just be a hypothetical injury. And I think that Missouri has, satisfied the burden of proof here that it will suffer, in fact, an injury. I think the Solicitor General is being a little tricky here, is trying to distinguish, the incorporation argument that just because it is not directly a state agency, that therefore, it should have to sue in its own right. But I think if you actually look back at the court precedents, that's not necessarily the case. I think that I recall looking back, and this was back in the fall when this issue came up, and CalPERS, Public Pension Fund in California is, California can sue on behalf of CalPERS, even though it's a separate entity, but it's still an arm of the state. And I think there's a lot of skepticism, I think we heard from the justices, that they actually are important or matter in fact.
And so it does seem likely that at least some of the justices probably who agreed to hear the case, are interested in getting to the merits. And there, I think it's interesting to spin out a little bit. President Biden, the Biden administration, has justified this loan forgiveness under the 2003 HEROES Act, the Higher Education Relief Opportunities for Students Act. And I will just read the operative section and some ellipses legalese here to leave out a little bit of the legalese, but it says, notwithstanding any other provision of law, the Secretary of Education may waive or modify any statutory or regulatory provision applicable to the student financial assistance programs as the Secretary deems necessary in connection with a war or other military operation or national emergency to provide the waivers or modifications. And so, Kim, part of what the justices were wrestling with is whether what the Biden administration is proposing to do here fits within the meaning of that statute and what Congress meant when it gave the Secretary of Education the power to waive or modify student loans in the HEROES Act. And let's listen to a bit of Justice Sonia Sotomayor asking a question on that topic.
The chief mentioned the $250 billion or the $500 billion. How do you deal with that? Because that seems to favor the argument that this is a major question.
Yes, Justice Sotomayor. So, of course, we acknowledge that this is an economically significant action. But I think that that can't possibly be the sole measure for triggering application of the major questions doctrine. In prior cases, the court has pointed to economic and political significance, but it's also reviewed a litany of additional factors that have demonstrated that based on common sense understandings of how Congress is likely to legislate, the agency is claiming extravagant regulatory authority that it doesn't actually have. And I think if the court were to just look at costs alone, it would take the major questions doctrine outside of that extraordinary case, because national policies these days frequently do involve more substantial costs or trigger political controversy.
Kim, what do you make of the idea here that the Solicitor General is raising that forgiving student loans en masse like this doesn't qualify as a major question under the Supreme Court's precedents that Congress needs to speak clearly on?
It's no big deal. You know, the Biden administration spends so much money. What's a couple of $100 billion more? I mean, it's really an extraordinary argument. He actually had the audacity to use the word common sense in that phrase, because I would think that most people who would look at this think that it's fairly common sense that the president doesn't have the ability to just wave a magic wand and take over Congress's job of appropriating money. Look, I think it's worthwhile stepping back here and just to round this back to what Alicia was saying on standing. If they can get this thrown out by arguing that the plaintiffs in this case don't even have right to bring the suit, they can avoid getting to the merit question, because the merit question is so hugely stacked against them. You have this legislation from 20 years ago, the Higher Education Relief Opportunity for Students Act, and it was so clearly designed to aid students that were in the military, to allow, if necessary, some waiver or modification of provisions for holders of student loans that somehow got swept into a war or a military operation. And yet what happened here at the beginning of the pandemic allowed for some forbearance of student loans in the beginning of the emergency. That ended. And then both the Trump and the Biden administration reached back to find this law from 20 years ago. Biden, burrowing even a bigger hole in it, claimed that he was able to forgive all of this student debt. Obviously, this is a major question. If the administration or this administration or any other administration can simply look back into some law that had nothing to do with the emergency at hand and claim that because that word is present, that they can declare such and just run around Congress and appropriate, $500 billion for some sort of program that they see a benefit for, but which Congress will not pass, that's a huge problem for the separation of powers. Of course, the court is going to have to look at that and understand the implications of saying yes to this. And again, that just gets back to why there's such a focus. They are keeping their fingers crossed that maybe they can get this tossed either on a mootness claim or on a standing claim, because I think the clear facts of this particular case are so glaring the problem of the merits.
Alicia, could you give us a little bit more background on the major questions doctrine? Because as I understand it, this is a relatively new development the Supreme Court is putting forward. And it was remarkable in this oral argument to hear the Solicitor General make the case that the major questions doctrine doesn't apply to benefits programs. And what she said was that if you give the administrative agencies the power to rewrite law on major questions, is the way I guess I would frame it, probably not the way the Solicitor General would frame it. But if you give the administrative agencies the ability to address these major major questions on topics that affect liberty interests, where somebody could be committing a crime or not, depending on how the agency interprets the law. There's a heightened review standard. And the argument she was making here was that that's not true for benefits programs. We're just talking about the amount of money that the federal government is going to shovel out the door or not, as the case may be.
Yeah, so the major questions doctrine, the left likes to say that this is a new doctrine, but really it isn't new. It goes back several decades, back to the 1990s to a case, MCI versus AT&T, which was regarding an FCC waiver. And it's expanded upon this major, the major questions doctrine in subsequent cases, often involving environmental regulation. And I think there was an FDA case back in 2000 that involved the tobacco industry and the FDA's authority to regulate it under its drugs and devices. But really, in the last few years, you've seen a more clearer distillation and articulation of what it is, in particular with the eviction moratorium case, the federal in which the CDC claimed authority to impose an eviction moratorium during the emergency, also citing public health emergency powers. And then you saw it again with the OSHA mandate, vaccine mandate for workers, which also basically claimed emergency powers to impose vaccine mandate on most workers in the private economy. And the Supreme Court blocked both of those ultimately on a statutory reading of the text, but also based on the major questions doctrine that the Congress did not give executive clear authority to impose these rules. And again, in last summer in the West Virginia EPA, which was considered a landmark ruling, the Supreme Court re-emphasized that the executive needs clear authorization from Congress when undertaking issues or taking actions that have such huge political and economic significance. The court specified it more clearly what could be considered a major questions doctrine and provide more guidance to the lower courts. But I think on however you interpret or however you read the court's decision last in West Virginia v. EPA, this is student loan forgiveness is a major question. And it's a little puzzling how the Solicitor General can argue otherwise.